How do you protect yourself after you've been involved in a slip and fall? Number one, you have to prove negligence most of the time of the premises owner with a lot of their own data, like their own security footage, their video surveillance, uh, their documentation of their floor cleaning, those type of things. And also they're tough cases because a lot of people start out with the premise that you're at fault. If you slip and fall somewhere, then you must be at fault because you should have been watching where you're going. So what is the law in Tennessee regarding premises liability cases? The general statement of law in Tennessee regarding slip and falls starts with this. A property owner is not responsible for injuries that occur on its premises unless, number one, it was caused by a dangerous condition created by the premises owner, or it was created by someone else with sufficient time to identify it and to clean it up. For example, there's a famous case in Tennessee that there was an egg spill in Kroger's, and they told a manager, and he was going to get a sign to put over it, and immediately after he left, that somebody else came and slipped on that egg, and they held that, well, it was created by somebody else, but there was not sufficient time to identify it and clean it up. So just because you've had a fall does not mean that the premises owner is responsible. There are certain things that you can do to vastly increase your chances of having a successful claim against a premises owner after they've created a dangerous condition. Number one, you need to document what caused your fall. Was it a dangerous condition? Was it water or oil on the floor? Was it a box sticking out where you couldn't really see it, or the edge, the corner of something sticking out? Was it open and obvious? Should you have seen it? These are things that are just need to be reviewed. If you have a chance and you're not severely injured or you have someone with you, you need to take photographs of it. You need to take pictures of it. Also, you need to give notice to the store owner immediately. They need to fill out an incident report. That needs to be done immediately without delay. I've had a case where a person fell outside of an O'Charlie's, I think it was, in a dangerous spot, and they left and went to the hospital, but they didn't give notice to O'Charlie's till about 2 weeks later. That was a problem. You need to let them know immediately, or have somebody, or at least call them and let them know. Try to speak with a manager. Document who you speak with. Document any witnesses that you have. If you're with somebody or you see somebody else around you, you need to document all of your witnesses. Just take a video of them if you can't write anything down. Just write that and just get their contact information. Another thing you can do is, if you've been involved in a fall, is look for surveillance cameras. Ask for surveillance cameras. If you've had a fall in a store, for example, look around and see if there's cameras located anywhere within your field of vision that more likely than not could have taken video of you falling. And we need to get that. Sometimes that's the only thing you got to prove your claim. And the problem with that surveillance video, is time is of the essence. Time is not your friend when you've been injured. A lot of these video surveillance and these camera footage, it gets written over by the computer every 2 weeks, 30 days. And so if you just sit around and wait, or don't call a lawyer right away, then that information may totally disappear. For example, a body cam, even from police officers, I think every 30 days that's written over if there's not a request to preserve it. Another mistake I see a lot of people make after a fall is they don't get treatment immediately. They wait, they try to tough it out, and insurance companies have a saying, if it's not in a doctor's note, it never happened. So you can say you're in all this pain for a week after the wreck, but if you don't go to the doctor, go to an urgent care or walk-in or emergency room if you're hurt really badly, you need to make notes of it and tell every provider that you see from head to toe every single injury that you have. Don't leave things out. Your neck may be hurting you worse than your elbow, but go ahead and list your elbow, even if it's just a small 1 out of 10, because sometimes those things will get worse. I had a claim one time where a lady was hit head on and she didn't tell her doctor that she had knee pain because she didn't. She had a fractured sternum. She could barely breathe. And after 3 weeks of laying in bed, she started to move more, and she was started to get on her walker and move. And then she noticed about 2 or 3 weeks later that her left knee was hurting. Turns out that she had a torn meniscus in her left knee, but she didn't know it because she was laying in bed dealing with her fractured sternum, which is the hardest bone in the body to fracture. So 4 to 6 weeks after the wreck, she gives notice that she's got left knee pain. And we fought in that case about proving that her left knee was related to the crash that she was in. Wasn't that hard to do in that case, but the point is, make sure you list everything that's hurting you from head to toe, because if you don't do it, the insurance company is just going to take that as an opportunity to say, this is not related, this is BS, we're not paying for this. If the adjuster calls you after a slip and fall, what should you do? You should not give a statement. There is nothing a statement does to help you as a personal injury plaintiff. There's nothing it can do. It can only hurt you. When I was an adjuster, I was trained by defense lawyers. I was given the questions to ask. They've got a set list of questions, and they're just trying to catch you with your guard down. Maybe you're hopped up on hydrocodones. Maybe you're under pain meds. But you do not need to give a statement. It does not help you. And they might use some tricky phrases like, well, in order to keep your claim open, we've got to have a statement. It's our policy and procedure. Well, that's their procedure. It's not the law. So that means little to me. It means nothing. So you do not need to give a statement. And I've had tons of insurance companies open claims they've allegedly closed. It's just hitting a button. But the only thing that really matters, you must make a claim within 1 year. And the best way to do that is call a competent attorney who handles these type of cases and knows how to handle and push your case. Lastly, I tell all my clients to journal your injuries. Keep a journal just for your eyes only of everything that happened to you in this incident. Write it while it's still fresh on your mind. And also journal how all these injuries have affected you. In 6 months from now, you may forget how badly these injuries have intruded on your life. You may forget all the people in your life that brought you food, that helped you walk, that took you to the doctor, those type of things. So journal all of that information, and that will prevent you from forgetting this stuff later. One of the things that if you are in litigation, you're going to be asked this question by every defense lawyer. They always ask this, and it's this. Tell me every way this injury has affected you. Well, if you've not journaled and it's been a year, you're going to forget a lot of things. But if you've journaled, I like my clients to say, well, how much time do you have? Because this is going to be significant, and I want them to know everything in the way this injury has affected you. So you need a good lawyer who can identify those things and protect you and protect your family. Thank you.